Hello, I'm Dan Marr from Hamlin and Kerrigan in Nashua, New Hampshire. I've been practicing law for approximately 36 years in New Hampshire and about 28 in Massachusetts, practicing in both courts. And today I'm going to be talking about personal injury claims in New Hampshire when there are several responsible people for that. So in a situation like that, you have a circumstance, perhaps it could be an auto accident, it could be a product liability case, which I'll talk about in a moment, and it's a circumstance upon which there are multiple people that are at fault. Here's an example. You have a car accident where maybe a couple of people are in road rage, and because they're in the middle of a contest with each other, one of them hits you. You're a pedestrian in a crosswalk. And that person that hits you in the crosswalk, because they were not paying attention to the other car, not paying attention to you in the crosswalk, seriously hurts you, and they have no insurance, and they don't have any assets. But the other person that's in the middle of the road rage with them does have assets. So traditionally, before the Tort Reform Act, people would go and sue just the person that was behind them that didn't hit, and the jury would only hear stories about how they were negligent and they caused the accident, and that person would be at fault and they could be responsible for the entire flow of the problems with your injuries. The Tort Reform Act says, wait, that's not fair. It's frankly, I think, primarily dealt with by the insurance companies' lobby. But anyway, there is some fairness to this issue where they say you should be able to hold responsible the person that the personal injury victim doesn't bring in. So that driver that hits you in the crosswalk gets allocated fault, and in that situation, the person that was helping them with the road rage or engaging in the road rage said they're both negligent for acting that way. Neither of them intended to hurt you. So it's a negligence claim. That person and both of them are at fault, and the jury gets to determine which one's more at fault, and that makes a difference as to whether or not there's who gets damaged, who gets an award of damage, and how much. So that's a big issue. In product liability cases, we had a case where we were representing somebody that was injured in a defective firework case. And in that situation, a defective firework. So the firework went off and it hurt the person very seriously. Very, very nice man. Before and after, it still is a very, very nice man, but he's seriously injured. And we didn't go after the Chinese manufacturer of the company, which was insolvent. It happens with some certain industries particularly, and it wasn't available. So we went after the distributor and the dealer, and they were making arguments that, look, we get to allocate fault to the empty chair in the trial, the manufacturer, and say they're the ones who are at fault because if this product was defective, it left the manufacturer defective. And that was the argument that they were raising. And if that carried the day, they'd be able to go in front of the jury and say, look, we're not at fault, we're not responsible, and we don't have to pay any damages for this. So in that situation, I changed the case to just an implied warranty of merchantability. There's a Uniform Commercial Code provision law in New Hampshire that across the states that have merchantability as a warranty. That's a contract claim, and contracts aren't part of the Tort Reform Act. So I had to go up to the Supreme Court to deal with that issue, but I did go up to the Supreme Court. The trial court allowed it to go up. They thought it was a novel enough issue to go up, and I thanked them for that. And the Supreme Court agreed with us and said, no, the implied warranty of merchantability is not a subject to this Tort Reform Act, so you don't get to allocate fault there. So you don't have to go after the manufacturer in that situation. Now, when you're dealing with car dealerships and stuff, you probably have a nice solvent manufacturer, but in this situation, that manufacturer was insolvent and we didn't have to go after him. So you got to think carefully about if you're injured in a personal injury case, you want to make sure that you have somebody that's familiar with this Tort Reform Act. It's called De Benedetto. There's a case called De Benedetto. There was a New Hampshire Supreme Court case that interpreted the act. You want to have somebody that's fully understanding of that. We can help you if you're in a situation like that, if the need arises. My name is Dan Marr at Hamlin and Kerrigan. It's 603-883-5501. That's 603-883-5501. And you can check out our website as well as nationallaw.com. National Law, all one word, .com, and you can check out our vlogs and other useful information. We have several very competent lawyers here that do personal injury work, and they can help you, and I could assist as well. So check us out, naturallaw.com, and look forward to the opportunity to work with you if the opportunity does arise. Thank you.